Okay. Hello, good afternoon to everybody.
Hello.
Yes, can you hear me?
Yes, hello.
Hello. So, can I start?
Доброго дня, пане Фабриціо. Раді вас вітати сьогодні. Знаю, що сьогоднішню зустріч ви хотіли розпочати з того, щоб дати відповіді на запитання студентів, які вони вам надіслали нещодавно. Тому, напевно, не будемо забирати часу в нас і в вас, і я вам передам одразу слово.
Good day, everyone. Mr. Fabrizio, we are glad to welcome you again. I know that you wanted to start today's meeting with answers to the questions of our students, which they sent you after the first lecture. Therefore, I will not take up everyone's time. I will give you the floor right away.
Thank you very much. Welcome again to the lesson. Thank you to be here. I will receive around 10 questions that were very interesting. And after the last lesson, I thank you for that. I will start answering with some of them, and then I will use some of them to introduce some matters of today's lecture. I will start with a question by Kadiza Alekberova. Are you here?
Yes, I am here.
Okay, perfect. Perfect. You asked me, in my opinion, how much will the situation in Ukraine and the world as a whole change after the Ukraine joins NATO? Well, from my point of view, I don't think there will be any substantial change in the sense that Ukraine, because of the war and for the process that started before it, was clearly oriented to be part of the, let's say, Western world, of the European Union, and also the NATO. I think that formally join the NATO, we will not change anything practically. I have to clarify that, unfortunately, because I don't know how much you know about that, unfortunately, this Ukraine cannot join NATO right now because there is an article of the treaty that forbids the admission of countries that have a current state of war. Basically, the alliance cannot admit a state that is already at war, because NATO, despite what the people outside said, is a defensive alliance. They are an alliance of countries that want to protect each other. And so if one of the countries is attacked, all the others have to react. They are obliged to react to help to defend it. That means that admitting a country that is already at war will draw all the alliance at war. And that's why it's not currently, unfortunately, is not possible. But I'm sure that there will be a full admission after the war, and everybody agree on that. Second question from Inga Yeremenko. Are you with us, Inga? I don't see any response. Inga? Okay. Anyway, Inga asked me, in my opinion, if Ukraine will get back the territories that belong to the country in 1991, at least by 2030. I think that this is possible, and I'm confident that will happen at the end of the war. So we have to be patient, have faith, and I think this will happen earlier than 2030. Then I have two questions that I put together because they are quite similar. One is from Ivan Shavaiko, and one is from Visevod Iskovich. Guys, are you with us?
Yeah, we're here.
Yes.
Okay. This is two interesting questions because they help me to create a link between the last lesson and this lesson. Ivan asked about the source of international law. They are very important because I'm listening, reading this question, because they are statutes convention. Why do we, the citizen, need to adhere to them, and do we need to improve them? Basically, the starting of this, the answer to this question is in the last matter we touched in the last lessons. In the last lesson, we talk about how the international law, of course, influence the external sovereignty of the state, but also the internal sovereignty of the state, and dictates what are some of the rules that are adopted by the state. That's why I think that's why it's important to have knowledge of the international rules and why we need to improve them. I think that there is a constant improve because law is not something that's mathematical. It's something that evolves with the society, with the situation. So new situation create new law and new dictated by new needs. And this is also valid for the international law, because as we see today, talking about the International Court of Criminal Court or the European Court of Human Rights, these are entities that were unthinkable 100 years ago. No one 100 years ago can think about an international court that were able to judge about the violations of the human rights by a country on his own citizen. But now we have it. They are a reality. Of course, it's still debatable the effectiveness of this court, but it's certain there was an improvement to have them. And we are still, time by time, step by step, improving all the system. So actually, we are trying to improve. Instead, Visevold asked why it is important to pay attention to the structure and the standards that are found in international law. Because the international law is, we don't realize much, but it's, and now we are starting the matter of, we enter in the matter of today's lesson. It's a critical element in politics and geopolitics and basically in the direction that this world is going to take. And this question introduced another question. Why do the state voluntarily submit themselves to the international law jurisdiction and undertake international obligation? There are two faces of the same medal. Why we have to take the attention to the international law, and why the state accept the international law? Because in some way the alternative to this is basically what is going on right now in Ukraine, a war. In the past, the alternative for diplomacy and settling international dispute was war or some kind of military action. With the progress of our society and the spread of democracy, the use of force was gradually reduced. Democratic governments are less keen on military action because they have to justify their action and the result of them toward the national public opinion, which can shift to be supportive to or positive. So, and this is exactly what you can see also even right now. I tell you that is when there is a war, this is a more common problem for the aggressor than the country that is attacked. But it's still something still valid today. And so in this situation, there was let's say an increase of use of democracy, because in the ancient past, when there were kings, when there were emperors, they just say, okay, I want this territory, I go to war. I want this right, I go to war. And no one objected. It was the king's right. And if you see a book of history, now we have, let's say in Europe, we have a period of half a century of relatively peace. But in the past, basically there was a war in Europe every 2 years or every years, and they lasted for decades because it was much easier. Now it's became more complicated, and diplomacy has gained much more importance. It has more importance before, but as we can make a quote of Clausewitz. Clausewitz say that war is diplomacy carried on with different methods. Let's say that diplomacy started to use less this method, but even diplomacy used in a relation between the state cannot be resolutive if the parties stubborn exist in their respective rights of sovereignty, creating a stalemate situation. Because what it means that? It means that when we consider a state as what is an area of full sovereignty, in which for his legitimate right to think he can do everything. When this sphere of sovereignty collide, from the point of view of each of these states, he has right and the other was wrong. So this is creating, and if they challenge themselves on this field, the talkings and the confrontation, even if it's in peaceful terms, will never have an end, because each of them will say, oh, according to my law, I'm right. And where there was no possibility to proceed and get a result. A typical case of this, it's the Rio Grande water dispute between United States and Mexico. By the way, I use a lot of example, as you know, because I think that a historical example is what can help you to visualize the situation in a more clear way. The Rio Grande water dispute started in 1895 because Mexico lamented the use and the diminution of the flow of the Rio Grande River due to the management of the waters upstream by United States. Rio Grande, maybe all of you has heard about it, is a big river that makes the borders, create the borders between United States and Mexico. It's mentioned in hundreds of Western movies, and it divides Texas by Mexico. Rio Grande is not always, not for its full length a border, and is not shared by both countries. In its upper part is only United States. Its spring is in the United States territory, and the United States in this part start to use the waters for irrigation and other use in a way that the Mexican government perceive as harmful of its economy. The Mexican lamented this with the United States, but the United States didn't accept the legitimacy of the Mexican complaints because they were referred to an area where the river flowed entirely in the U.S. territory. Therefore, an area that was under the American exclusive sovereignty. Is exactly what I said before. The American government say, why I should care about your complaints or be worried about complaints or understand your complaints when you complain of something that my citizens do in my territory, in an area that is in my sphere of exclusive sovereignty. And from his point of view, the United States government is right, because the Mexican seems, of course, the Mexican was not wrong from the point of the common sense, because of course, altering the flowing of the river, reducing the quantity of the water, created damage downstream, where the river were shared between the United States and Mexico. But apparently, from the legal point of view, United States was right. They say you complain about something that is in my exclusive sovereignty, and if I don't perceive that my citizens are doing something harmful or something illegal under my law, I'm not going to do anything. So that was and the matter takes some years to be settled, because the US were technically legally right in reference to the exclusive sovereignty. But this was not able to produce any concrete results in settling the dispute, as I said before. The matter was finally settled 11 years later in 1906 by the Rio Grande Agreement, that on its extents in the form is named Convention Concerning the Equitable Distribution of Waters of Rio Grande for Irrigation Purposes. With this convention, both US and Mexico renounced part of their sovereignty, getting in exchange some comparable benefits toward the sovereignty of the other state. What it means? It means that the United States accepted, let's say, an interference in their sphere of sovereignty regarding how to use the water, and get the possibility to make an interference in the Mexican sovereignty regarding their use of water. Coming back to a point, the states submit themselves to the international law jurisdiction because they receive comparable benefits from the partial announcement of their jurisdiction. Basically, the international law produces mirror rights by the way of reciprocity. Exactly as happened with Mexico and United States. United States give some rights to Mexico how to decide the use of the water of the Rio Grande, and they gain some rights about to tell Mexico how to use their part of water of the Rio Grande. This is why the international law is important and why the states submit to its jurisdiction. First, because solve legal stalemate. Second, because the state accept to submit to his jurisdiction, because it causes a loss of sovereignty, but the gaining of rights. Because the sovereignty lost by the states produce right towards the state that gains the sovereignty. The rights produced by international law obligation were mostly bilaterals, bondly a state toward another state that was committed to submitting the same bonds and applying the same rules. Because at the beginning, the international law was produced mostly by bilateral treaty. So let's say in the case of Mexico and United States, the bilateral treaties binds the signers to each other. And we can make an example about that with the bilateral treaty against double taxation. I don't know if you're familiar with that, but many states sign a bilateral treaty how in regards how should be the taxation of a subject who is national, who is citizen or a citizen of one country and gains his income in the other country. For example, an Italian who has interest in Ukraine and receive gains in Ukraine, or an Italian company who has investment in Ukraine, or it's happened to me because I have clients like that, an Ukrainian company who has factories or investment in Italy. Technically speaking, for example, if I am a company who is a Ukrainian company who has a factory or a controlled company in Italy, I should pay in Italy the taxation because it's for on the income, because it's where the income is produced. Then I should export everything to Ukraine, where they should be taxed again because are part of my income as a company. Of course, this will be unfair because having an investment to abroad will cause a double taxation on the common when coming to this investment. And there are other cases. For example, this is not it's not common in Ukraine, but there are a lot of Italian, German, French company who has investment in at London Stock Exchange or at Wall Street. So how to manage this type of situation? This type of situation, or another case, for example, are the inheritance. I am, for example, a Greek citizen. I live in Italy. I have my life in Italy. I have bought real estate property. I have bank account. And I die. All my relatives are in Greece. How to manage the situation? Because we have two countries with two different, all of them are, they have a taxation of what you receive as inheritance, but with different rates, different value, and this is something that be harmonized. That's why the country signed double treaties against double taxation, that we are bilateral treaties that decide how to manage the situation that involved both the states. So, as we say, the right produced were mostly the bilateral. But after the Second World War, the thing changed. After the Second World War, there was a progressive affirmation of the erga omnes rights. Erga omnes in Latin means towards everybody. There are rights that are recognized by all the state towards the community of the state. The erga omnes rights are closely related to the humanitarian rules adopted to protect the human society from war crimes or inhuman crimes. I make a note, this is a matter that we touch a lot today because it's one of the focus of the lesson. One typical example of this renouncement is the renouncement by the state to use force to manage the dispute with the other state and the bound to respect the territorial integrity of other states. This is these are two statements that are present in the United Nations charts and in a lot of international documents and treaties. It's the refuse to war, the respect of the national integrity of the other country. To us, especially in today's situation in Ukraine, it seems something that should be natural. It's something that should be always applied, but it's something that is not so basically. It was not always. It was something. It's a principle that are not always accepted and respected. And legally, in the past, before the United Nations charts and other documents, it was not illegal to infringe this principle, and it was in the right of the nation to declare war after to another nation, and in some way it was a right of a winning nation of a war to get spoil of war or compensation, getting chunk parts of the loser territories. It's something that it was quite common in history. it's, if you think about, there is a region is between France and Germany, probably you know it, Lorraine, Alsace-Lorraine. Alsace-Lorraine is a mixed region between German and French. The population is mixed. And this region changed hands more or less 3 times in less than a century. There was a war, there was 1870 war between Germany and France. The Germans warred and take this region. There was the First World War. The French was part of the Entente that win the war and get back the region. Then there was the Second World War. The German, let's say, win the first round with France and get back from the Vichy government Alsace-Lorraine. And at the end of the war, end of the second round, French get back Alsace-Lorraine. And this is, I tell you, to connect all what you said in regards to the, or that we said before, in regards to the single individuals in relation to the international law. It's not something that is high politics, only high politics, and something that passed over our head. But there was even legal consequence for the single individuals, because when there was a treaty with between the Nazi Germany and the Vichy government in regard Alsace-Lorraine, Alsace-Lorraine, for this government legally passed to Germany, the German drafted the young men that were that inhabited Alsace-Lorraine into their army. After the war, what happened? Alsace-Lorraine go back to France, and the new French government at the beginning started to make trials against these young gentlemen, because from their point of view, they were drafted, they were considered like volunteers in an enemy army, while they were instead they were drafted in a moment where legally, because not everybody recognized it, but the region was part of Germany, and so not answer to the army call was a crime. So then there was, I think there was, let's say, the position of this young man was considerably different, and there was no legal persecution against them, because they are not, they didn't volunteer.
Де? Де ти таке чув? Де ти таке чув? В мене ні. Я це.
Hello? I hear some voices. Okay. Okay. So we go back to our the obligation imposed by the international jurisdiction were at the beginning bilateral, and then they became for some part toward everybody. Another important point connected with the acceptance of the jurisdiction of international law is the breaching of the international law. What happened for the breaching? And I have 2 questions that were one still one again from Inga Yeremenko, that I don't know if she joined us, that asked me, how do you think international law should change after the end of the war? This was referred to the war in Ukraine. And Sofia Pagliarelli. Sofia is with us?
Yes.
Okay. What are the challenges and the problems facing international law in the light of the contemporary geopolitical events? I think that the matter of the question is more or less the same. The problem is the breaching of the law, how to enforce the respect of the law, especially when the breaching of the law is referred to important international principles like the non-aggression, the refuse of the use of force, but also in what are in the let's say sounds strange, but day-by-day matters during the wartime, like the violation of the human right, of the law of war, and so on. The international law is very it's complex to be applied, because, as we said before, the system is not completely, but very different from our domestic law system. In the domestic law system, we have a legislative body, we have a judicial body, and we have law enforcement agency that put in execution the law, and it is in charge to enforce the law. In the international law system, we don't have this. We don't have a central legal enforcement agency. But we have to say that, luckily, many international laws are still respected. Many international law rules are applied and voluntarily complied by the state on daily basis without us even realizing it. One example are, again, the double taxation treaties. We don't know it when probably you work as a professional or a member of a state agency. You decide if an individual should pay taxes in Ukraine, so should pay taxes in US, or the reverse. In this case, you apply the international law, and the subject of your decision, that of course can be challenged to a court or another, he will not realize it, but he will subject it to the international law. It can be agree with your decision, or it can challenge the authority in front of the court, but it still will be always under the dome of the international law. Unfortunately, as we've seen, in the case of breaching of international law, the international legal system, there is not a centralized enforcing authority, even if there are several international judicial authorities. In regard of that, we have seen the International Court of Justice. Today we'll see two more international courts. We see the European Court of the Human Rights and the International Criminal Court. And there will be, I think, quite interesting because in addition to being involved a lot with the current situation in Ukraine, I will dedicate some part in the formation of this court and the law that they applied, and you understand how the complexity of the international legal system and the compromise that to be adopted by the state to try to create a system that is fair for everybody. Luckily, the breaches of the law that request an international judgment are quite rare. Because in the international law system, we find the same psychological mechanism as the domestic law system. The average individual do not follow the rules because he fears the sanction or breaching the law, but because the laws reflect his interest and his social values. This we are entering in a field that is called the sociology of the law, the philosophy of the law. I think it's a mention quite interesting because if you think about, you are probably all model citizen, you all respect the law, but I don't think that if you, and I think you will agree with me if you start to think about it for a minute, you don't do because you fear what will be the consequence. Of course, you say, I go to jail if they catch me, and many people don't do it. But at the starting, it's not that I don't steal because I fear that they could catch me. I don't steal because I think that stealing is wrong. I don't want anything to be stolen from me. Because if I start stealing, everybody starts stealing, it will become a chaos. The same or even worse with killing or with any kind of crime. It's like, I think the more suitable example are driving on the street. If everybody go where he likes, keeping the direction and the side of the road that they want, we travel for 5 minutes. Then someone will crash against us, and we don't go anywhere. The same is for our society. Laws are, as I said during the last lesson, the law is a product of the society. Is what the society needs something, and it produces the law to go in that direction. It's a system that keeps the society together. So when breaching the law is like to breach the way of life that we have decided to follow. But still keeping our attention of the breaching of the law, there are 2 cases in which a state is pushed to breach the international law. One is the lack of coordination and common interest between the national authority in charge of drafting the international agreement and the national authorities that are called to comply with it or face the result of compliance. The second is the rising of political tension to a point that the particular interests of a state are perceived as more important than the respect of international law. Let's start from the beginning. That seems something very, let's say, complicated. The lack of coordination and common interest between the national authority in charge of drafting the international agreement and the national authority they are called to comply with it or face the result of the compliance. Basically, what it means, it seems that there is a guy who goes to meet the foreign representative. They decided to some rules between the state to manage something, but he didn't consult with another guy from his own state who is in charge to enforce the law or to coordinate the enforcement with the law, with this law, or the respect with this law with the national law of the state. This lack of coordination, common interest, could happen because the main objective of a state signing a treaty is to gain rights for itself and its citizens. But in ultimate instance, the gain of this right could imply some downside not previously imagined. Basically, it's related to what we do, we talk before. We talk about bilateral rights. So I sign an agreement, I renounce my sovereignty, part of my sovereignty toward another state, but because I think I could get a right and probably an advantage that compare what I lose for me and for my citizen. And it can be correct, but sometimes it could not be in this way. There could be some downside in what I'm giving and in what I'm receiving. Maybe these downside are not evident to the subject in charge to negotiate the treaty, but could be very clear in the eyes of other part of the same government. As I say, for example, the economic department, who is in charge later to harmonize the treaty with the national law, or maybe with the national economic policy. This downside, in the eyes of some part of the government or the state, could alter and reduce the value of the reciprocity. So I give you some right, who negotiate the treaty think that there is an equal balance. Behind him, there is another guy that when receive the treaty say, you are crazy. This is something that damage our economy, damage our way we want to develop, is not something that is completely, is not strictly based on the law, but it can be strictly, it's connected with other factors. And about this, there was another question that was, in my personal opinion, connected to this. Yes, proposed to from Daria, Buyanov. Daria is with us?
Yes.
Okay. Can the ecological problems faced by humanity change it, or will be a personal still interested prevail? This is, Daria, this is exactly what we are talking about. Because one scholastic case of the breaching of the international agreement, of this type of breaching of the international agreement, happens in the agreement on the environment. When, for example, when there are limits on the production of gases, of any type of wastes. Everybody, it's a difficulty when there is a difficulty to negotiate this type of treaty, because aside from the difference of legislation, each country has its own economical policy, economical goal, and its own also political direction, because at least in democratic countries, there are, or should be, changes of government, and therefore changes of politics that can alter the goal and the direction in which the country wants to go. So this is exactly the problem of the personal interest. In this case, it's the personal interest of a state who think to represent the interest of his country. There was a famous treaty signed in the past that was in which during its formation there was a lot of conflicts between third world country and Western countries, because the third world countries say we have to develop, we have to increase our economy, increase our standards of life. Of course, there are problems for the environment, but we have our primary goal is to increase the standard of life of our people, like you did before. So it's a quite complicated matter, because also this is, from a historical point of view, the most advanced country in some way. I think this is not a popular subject, but unfortunately in this way, they try to charge a bit the burden of what they did in the past to the undeveloped country that tried to reach that development. The other case of the breaching is the breaching due to the rising of political tension. The case of the breaching due to political tension, it could happen according to scenarios. A voluntary breaching of international law rules with the purpose to question their principle, and in the last instance, to open a door to a future change of international law. Second, a misinterpretation of the precepts of international law, or an instrumental interpretation of the international law to justify the action of the breaching state. let's put attention on the first case. So the breaching with the purpose to change the international law. The second, we will talk a lot about it. Sorry, I'm a bit stuffy, and I hope you will forgive me if I don't speak clearly as usual, but I get a little fever too. One important case of the breaching of international law with the purpose of change it is the Truman Proclamation of 1945. This is a case of voluntary breaching of international law. And it was, could sound strange because Truman was president of the United States, but we will see the United States are I think they are the most democratic country in the world, the birthplace of the Western democracy. I have a high evaluation of them, but in terms of international law, they are not always keen to respect it, with no offense for anyone. The Truman Proclamation. With the Truman Proclamation, the US unilaterally extended its sovereignty on the seabed and the area under it up to the limit of the continental shelf adjacent to the US coastline. What's happened in 1945? There were territorial waters already established with the international laws, and they were clearly defined in the international waters. They say that the state has full sovereignty on its own territory. In 1945, the President Truman decided the United States sovereignty is not on only on the territorial waters. Our sovereignty is on the seabed and the area under the seabed to the limit of the continental shelf. The continental shelf is that area close to the continent that is before the abyss of the open sea. Of course, this was referred to the coastal waters, to the continental shelf of the continent in which the United States were present. United States, in America, the area of the Caribbean, and in the Pacific in several areas. What is the purpose of the declaration? Economics. Because what was important was not what was happening on the water, on the surface. The importance was, the most important thing, what was under the seabed. Because 1945 were the time where the company and the nation started to think about the richness that were under the seabed. The possibility to drill for oil, the seabed, to look for other minerals, and so on. And in this case, the United States put forward the hand and say, what is close to us is ours. The Truman Proclamation was unchallenged at the time and produced the effect of a similar declaration by other countries. This declaration created a new customary law that, in the last instance, was coded in 1958 Convention of the Continental Shelf. So there was an intentional, this was its school case. We have an intentional breaching that create a change of international law. Then we have the second case, a misinterpretation of the precepts of the international law, or an instrumental interpretation of international law to justify the action of the breaching state. Here, we are going to speak, and we speak a lot today about this, about the war between Ukraine and Russia. And I have four more questions that I would like to answer. These are questions all connected to the human rights violation. And I think they pop in your mind for the current situation. One is from Alina Artemenko. Okay, she asked me, how does the international law respond to the human rights violation, and what mechanisms exist to ensure their protection? Alina, are you with us? Okay, doesn't seem she is with us. Then we have a question from Inga Yeremenko that asked me, what do you think will be the decision of the International Court regarding the crimes committed by the Russian Federation in the Russian-Ukrainian war? And then last question from Daria that she answered before. The Declaration of Human Rights states that all people are equal, but as we know, it is not so. How to ensure what is written corresponds to reality? I have to make a promise. Before I say that the recourse of force, the use of force, is less common now, at least in what we call the civilized country or the most developed country, because we are, let's say, there is the problem of acceptance of what could be the use of force and what could be also the external image of that the country can give using the force. But this is, but the use of force, unfortunately, is still happened. Aside the reduction of the frequency of the use of force, the new legal production in the matter of the human rights of the last 15, let's say now not 50, but 70 years, produce another effect. Usually now, no one say, I attack you and I want this, and you have to give him to me because I'm bigger, tougher, and more armed. In the current environment, anyone, even trying to do the nasty thing, like our neighbors, the Russians, or the Russian government, because I don't want to generalize, try to justify themselves for what was not here the last time. I say our, because my wife is Ukrainian. I lived in Kiev before the war, so I'm not like an Ukrainian, but I'm involved like an Ukrainian. Everybody anyway tried to justify what is doing, misinterpreting or twisting the nature of the international law. They tried to create a smoke screen. And this happened also with the Ukrainian-Russian war of 2022. Also in this case was an instrumental interpretation of the international law. Contrary to what could be thought, Russia tried to justify the aggression to Ukraine with the basis of international law. And Ukraine responded to that with its own argument, starting a legal battle that developed in parallel to the military operation. We have also not only military, but a diplomatic and legal battle with Russia right now. What are the arguments that Russia invoked? Russia invoked Article 51 of the United Nations Charter to justify its aggression against Ukraine as a self-defense action. Sorry, but this makes me laugh because this is something ridiculous. But this is what they say. Russia also sustained that the attack on Ukraine was motivated by a humanitarian reason to protect Russian minority from alleged genocide perpetrated by the Ukrainian government. And Russia dared to present this to the General Assembly of the United Nations. Luckily, the United Nations General Assembly rejected Russian motivation, and the attack in Ukraine against Ukraine was condemned by a large majority of the countries. In regards to the alleged protection of the ethnic Russian from genocidal menace, Ukraine started the lawsuit against Russia in front of the International Court of Justice, invoking an abuse of the 1948 Genocide Convention by the latter. Sorry, I hear some voices in addition to the action started by Ukraine, 43 states have declared to voluntarily intervene in the case in support of the latter. Basically,
Just a minute. Олександра Ніцька, будь ласка, вимкніть свій мікрофон, тому що він заважає лекції. Sorry,
Okay.
Fabrizio, please continue.
Tell me when I can continue.
Yeah, please go ahead.
Okay. Basically, what's happened? If we were a normal court, what's happened? Russia say that there was a genocide taking place in eastern Ukraine, and Ukraine, I think wisely, from a legal point of view, challenge Russia because for the abuse of the genocide 1948 Genocide Convention in front of the International Court of Justice. The International Court of Justice, we see it later in detail. It's a court that was established in going ineffective in 2002 and was established to judge on war crimes, on genocide and had other very cruel and important crimes. And the other, I think, great things is that other 43 countries decided to support Ukraine because considered they were not involved in the war, but what is the Russians said in front of the United Nations Assembly, General Assembly, was considered them a violation, an important violation of the 1948 Genocide Convention. Ukraine also started a lawsuit against Russia in front of the European Court of Humanitarian Rights. We will see also this court. This is a different entity because the International Court of Justice was established under the supervision of the United Nations. While the European Court of Humanitarian Rights was created by the Concilium of European Council, under the European Council. So Ukraine also started a suit against Russia in front of the European Court of Humanitarian Rights for massive violation of humanitarian rights committed by Russian troops during the military aggression. The violation reported included alleged violation of the right of life, the prohibition of torture, slavery, and forced labor. Not something light. And the European Court of Human Rights promptly urged Russia to refrain from attacks against the civilian population and the civilian objectives, and to ensure safety of medical facility and the medical personnel. I tell you, Russia was also part of the European Council, also accepted the jurisdiction of the European Court of Humanitarian Rights, and immediately after the starting of the war and the lawsuit by Ukraine, the court immediately issued an alert to Russia to stop doing what he was doing. Not, of course, not to stop the war because it's not in his power, but to put again the military action and the track of what could be done and what not, and avoid what not be done, especially the targeting of civilian, the action against civilian, and the action against protected targets like hospital or medical personnel. And at the same time, for the effect of this, because of course, if the European courts state this, it's because there was a reasonable evidence that these events were happened. Russia was expelled from the Council, European Council, and from the membership of the court. In addition to the action against the state, the military aggression against Ukraine was internationally persecuted at individual personal level. So there was another, and now here we go into the Criminal Court of Justice. The International Court of Justice public prosecutor issued an arrest warrant against Vladimir Putin and Maria Alexeyevna Lvova-Belova, the Russian Presidential Commissioner for Children, for the war crime of unlawful deportation and transfer of population. In this specific case, the crime regards the forced transfer of Ukrainian children to Russia. It's something that is very notorious. I'm not telling you news, something happened last year, but I think it's important from the legal point of view, because in this case, there was an autonomous action of the public prosecutor against people in Russia that committed these alleged crimes. This is another, let's say, I think this is, I think it's important. I also give you, let's say, a vision of how the two courts operate. Because the European Court of the Human Rights have as an objective the country, issue a warrant, and it's taking action against the country. The International Court of Justice target the people who are in charge, no more, not we'll see later, the International Court of Justice target not only the people who materially did the criminal action, but who also, and this is the most important, the people who order the criminal action. Let's talk about the European Court of Human Rights. Later we'll speak about the International Court of Justice. The European Court of Human Rights was established in 1959 as a judicial body of the Council of Europe to judge the alleged violation of the European Convention of the Human Rights. The European Convention of Human Rights was signed in 1950 and entered into force in 1953. The court has jurisdiction over all the 46 states that are members of the convention. As we talk about the international, we are talking the International Court of Justice before. Before we are talking about the International Criminal Court when we talk about Putin and the other lady. When we talk about International Court, we already see that there was a little problem in regards to on who this court are able to judge. We already talked that the International Court has a kind of arbitration court. The arbitration court, I make a parallel with the domestic civil law, are different from the natural court that are the tribunal and the legal system of a country, because are private court. The parties decided to hire a judge or more judges to decide the dispute, to settle the dispute with an arbitration. The International Court, as we said the other time, have a kind of same nature, in the sense that they have jurisdiction over the country that accept their jurisdiction. And in this way, it's like two parties that decided to to be part of two parties that decide to hire a private judge. In the court, European Court of Human Rights, you are still in arbitration, but it's in, let's say, in a lighter form, in the sense that if you are a member, if you want to be a member of the Council, European Council, that currently include all the European countries going far to Azerbaijan, Georgia, Armenia, Turkey, let's say also countries related to Europe or the far edge of Europe, you have the set, the European Convention on Human Rights, and you are also should accept the jurisdiction of the court. So basically, if you are European, this court have the right to decide if what you are doing is wrong or right, is right or wrong. The judgment in front of the court against the member state can be requested by an individual, a group of individuals, or another state member. Basically, we have three types of actor, of plaintiff. We can have a single person who can consider himself discriminated or abused by a state. A group of individuals, they can be an association, they can be a committee or whatever. And we have another state member who can be also to pretend that it was a violation of the human rights by another state that also involved itself. For example, an abuse, for example, for one country who is a plaintiff against another state because it thinks that his citizen living in the other state are discriminated according the European Convention of the Human Rights. Its residents abroad are discriminated. In addition, other important thing, the defendant in this cases are always a state. So it can be individuals against state, state against state, group of individuals against state. In addition, to rules of judgment, the other major activity of the court is to draft advisory legal opinion for the European Council. This is something that we already see with the International Court of Justice last time. The International Court of Justice make a judgment in the dispute between the state, but also give legal opinion to the United Nations. In this case, the European Court of Human Rights give draft legal opinion for the European Council. It is considered, the European Court of Human Rights is considered as a source of legal doctrine because it produces a continuous interpretation of the principle of the Convention in reference to the modern day reality. This is something very interesting from the theoretical point of view, because usually the court produce legal precedent. Sentence that can be used in the following as a base for the following judgment. Usually, doctrine is produced by professors, by persons who study the law and develop their own opinion. In this case, the European Court of Human Rights has been recognized to be able to also to produce doctrine, because it evaluates what is the situation, what is the time, what is changed, and adapt the convention of the human regarding the human rights to what are the current times. And this is something quite important. So it produces also an analysis of the convention. It's quite important because there is a big difference between doctrine and the legal precedent. The legal precedent is something that once is issued, it stays there. It doesn't move, it cannot be changed. The doctrine is important because it changes with the times, with the opinion, with the evaluation, with new ideas. And it helps going back to one of the questions we see before, it goes back to the development of the legal system, and in this case, especially the international legal system. I think, and the European Court of Human Rights is considered the most prolific and efficient human rights court in the world, but it meets its limit in terms of application of its judgment. Like all the international court, this court is not assisted by an enforcing agency or authority that secure compliance with this judgment. Therefore, the member state comply with this judgment only if they want to. Still, we are in the same situation. We don't have anyone who can force a state who doesn't want to apply a judgment to apply this judgment. So it's very efficient. I think has produced almost almost 70 years. I think it produced almost 1,000 sentences. Not all have been enforced because it's based on the decision of the state that received the decision, whose action is under scrutiny. The average compliance rate of the judgment by nation is 53%, with the lowest rate of compliance in Russia, Hungary, Albania, Finland, and Azerbaijan. I'm not surprised about Russia. I think they have around the 5% of the decision against them applied, or between I don't remember, this is 5 or 10%. I'm quite surprised about Finland. That is a very democratic country, but it could happen. And the highest rate of compliance is detained by the highest rate of compliance is detained by the Principality of Monaco, Luxembourg, Czechia, and Estonia. Monaco, Luxembourg, and Czechia have 100% compliance to the judgment, even against them. Estonia, 98%. I think this we can say it's real democracy. Let's talk about the International Criminal Court. The International Criminal Court, it's a very interesting judiciary institution. It has a very complex history that I think is important to examine in detail. It was created with the Statute of Rome and adopted during the diplomatic conference in Rome on July 17, 1998. And the statutes were ratified in 2002. It was preceded by the court of Nuremberg and Tokyo, which were created at the end of the Second World War, and especially international criminal courts that were created to judge the war crimes and the crimes against humanity committed during the war between the former Yugoslavian states from 1991 to 1999 and the Rwanda genocide in 1994. Let's clear a bit of the field. We already posed the boundaries, the object of the court: war crimes and crimes against humanity. The first day, in some way, it was inspired by the court of Nuremberg and the court of Tokyo. A lot of people that were established at the end of the war to judge the German criminal of war and the Japanese criminal of war. Just a note. Everybody knows Nuremberg. Very few knows about the court of Tokyo. Actually, if you make a compare between the courts, what is the evidence put in front of the court of Nuremberg and the evidence brought put in front of the Tokyo court, the Germans look amateur in compare of Japanese. Really, it's because the crime committed by the Germans were terrible. The crimes committed by the Japanese were out of the human imagination. Also because they started before the German, because the war crime of the Japanese started in 1936 with when they declared war to Japan, sorry, to China, and to China. Sorry. And so it was based on this court. This court was a pivotal event in the history of the humanity, because it was, aside from the brutal crimes that they have to judge, they were the first case that a nation that won a war decided they have the power to judge the loser. And it was something that create also and still create now some doubts. It never had been before. In all the human history, there were winners and losers, but never the winner decide to punish personally the loser. There were vindictive, there were killing of kings, there were some type of situation, but nothing structural like the courts of Nuremberg and Tokyo. There was, at the end of the Napoleonic War, there was a proposal to put on trial Napoleon. but no one of the Allied power was willing to do it, and everyone do it. Actually, at the end of let's say what was the first period, Napoleon was exiled on the Elba Island. He get a small kingdom, a small army, and he was exiled there. Then he was exiled again after Waterloo to St. Helena, but no one thinks to put him on trial. At the end of the First World War, in the Versailles Treaty, there was the request of the intent to Germany to put on trial the Kaiser under the accuse that he was the one who started the war. Personally, from an historical point of view, this was not correct, because the war was not started from Germany. The war was started from Austria and Serbia, and there was a domino game between the other nation that caused the world conflagration. But for sure, the Kaiser was not the main responsible. If he's put a lot of effort in transform Germany in a military power. Of course, there was a situation of war crime, even committed by the Germans, because you don't know if you have no history. It was something that was a huge event called the Rape of Belgium. Basically, the German forces occupied Belgium. They were afraid of partisan or franc tireur, and they committed mass murder of civilians. Anytime they have the fear to be attacked behind the line, they they dismantle factory and take it away. They take it away, everything valuable. Something like the German did in the Second War, but this was not in the accusation for the Kaiser. And there was other situation of genocide. For example, the Armenian genocide by the Turkish, they were not taken in consideration at all at the time. So there was this request included in the Versailles Treaty, but it was never enforced, because there was a revolution in Germany, the Republic was declared, the Kaiser escaped in exile to Holland, and Holland say, no way, I'm going to give him to anyone. So the question was closed. At the end of the Second War, there was Nuremberg and Tokyo. It was, of course, in some way, it was necessary, because the crime committed were very, very heavy. There was something that was never seen before, at least genocide never seen before in this scale and with this organization. Maybe is doubtable the identity of the judges or the qualification of the nation, the winning nation, to judge, because of course you cannot never compare Germans and Japanese with the American, British, and Russians and Free French or Welsh. But even the Allied troops were not completely saints. There was case of war prisoner killed. there is the famous Katyn massacre by the Russian, in which were killed thousands of Polish officers and military officer and Polish military officer. So it was a kind of complicated. There was but anyway, it was something that it has to be done. There was a lot of debates about the possibility to create a court for war crimes, for genocide, and so on. But after the Second World War, the Cold War erupted, and this slowed down the process. At the end of the Cold War, we have two crises. The former Yugoslavian wars and the Rwanda genocide. And this push, they were created to ad hoc court. I think that I don't remember when it was disbanded, the Rwanda genocide court. The Yugoslavian court, I think, was disbanded in 2011 after the judgment over the Serbian general that was last war criminal to be captured, the General Mladic. Also because we see something that was just seen before, only during the Second World War. But I tell you that there will be, during the last 70 years, there should be many cases for ad hoc crimes. One of the, I think, most terrible crime was the genocide of the Cambodian people by the Khmer Rouge regime. They killed basically in numbers something like the 40% of the Cambodian population. Anyway, in the 90s, the Cold War is finished, so no more crossed veto, and there was this need. There is the idea was start of international court for this type of crime was resumed, and was resumed at the end of the 90s for the initiative of a small country, that Trinidad and Tobago, that probably it's very unlikely, but actor, but this highland state decided to push and actually started again the process. The International Criminal Court is in charge in investigating and persecuting four main types of crimes: genocide, crimes against humanity, war crimes, and crimes of aggression. The International Crime Court has a technical jurisdiction over crime on three cases: if the alleged crime is committed within the territory of a state that signed and ratified the statutes of Rome, that we'll say later is the base on which the court is created; if the alleged crime is committed by a citizen of a state that signed and ratified the Statute of Rome. So, territorial jurisdiction, personal jurisdiction, So they have sovereignty of the people of the state to sign it and ratify the statute. And if the crime was referred to the court persecutor by the United Nations Council. So still, we are in the area of the arbitration, because of course, to be subjected to the court, your country have to sign, but we have an additional case. If the case is referred to the country court persecutor by the United Nations Council, and so on, if the denounce came from the United Nations Council, the court persecutor can ask for a judgment, even if the person is not the national of a state who signed the convention. This is something very, very important. Just a small note about the technical genetics of this court. We say that is based on the Statute of Rome. The Statute of Rome were drafted during a diplomatic conference in Rome that happened in 1998, and it was called by the United Nations. It takes place at the FAO, the United Nations organization in charge to fight the problem of famine around the world. It was everybody take part of this convention, this conference, but let's say that not everybody were willing to sign a declaration or a statute after that. There was a lot of restraint from many countries, and but everybody want to be there, because not to be part of this conference will be a huge loss of face for each country. So everybody sent their representative there. The countries were not willing to sign, and there was a lot of popular movement to have something approved. And I think Italy was in first line, and I'm proud of this, to get the document signed. Going to the technical part, as for the International Court of Justice, the International Criminal Court, in some way, it's an arbitration court. From a political point of view, the authority of the court is limited to the country that signally ratified the Statute of Rome and the following amendments to it. So there was a statute, and then there was amendments that were decided later. Technically speaking, there is the Statute of Rome and the International Criminal Court create a system that is quite complicated, and to which there is not a full compliance by many of the countries. In regards to the signature and ratification of the statute, we can distinguish 4 different steps: the signature, the ratification or accession, the ratification of the single amendments, that's where create later, the approval of the complementary and cooperative national legislation. When the the Conference of Rome ended, all the countries signed the declaration. No one who was there, almost no one who was there, not signed, because it would have been a huge loss of face. But the representative who signed the declaration have to go back to their government, to their parliamentary assemblies, and ask for the approval according what was the diplomatic process in each country. So we need a step 2, the ratification. The ratification, or we have accession, because if a country was not present at the conference, it not signed, after I think 2002, it doesn't have the signature and later the ratification. They simply have the accession, that means signature and ratification in only in a single step. Then there were the single amendments that were approved, and that they need to be they need ratification too, because there are changes to the Statute of Rome. Final step, approval of the complementary cooperative legislation of the nation, because the court judges and the crimes according what is the statute as is rules from the statute. But each country need to approve a law that allow the court to operate on its territory. Basically, there should be a law that decide and approve the fact that one citizen of the country who is under investigation from the court can be arrested and given to the authority of the court. Otherwise, because otherwise, if I say, okay, I signed the treaty, I'm part of the court issue a warrant, an arrest warrant against one of my citizens, and I don't have any domestic law that allow me to arrest him and put him under jurisdiction, is illegal. It's illegal according to my domestic laws. We see different type of law. Complementary, because they complete the area in which the international court rules are not detailed. Cooperative, because create a link from the national or domestic legal system and the legal system in which the International Criminal Courts operates. This first step create a kind of Russian salad system, because we have countries who did something, who don't did, and they don't did other things, and so on. Basically, the statutes were adopted at Rome on 1998, but the treaty of that created the International Criminal Court entered into force only July 1st, 2002, when the minimum number of 60 ratified state was reached. Basically, the treaty was signed, 30 statutes were signed, but there was a rule that until 60 states not ratify the statutes, it was not valid. And this number was reached July 1st, 2002. As a consequence, the International Criminal Court can persecute only the crimes committed after July 1st, 2002. This is basically very important because we don't go so far, because usually the court judges something that is contemporary. But it's also important because this creates a parallel rules. A country who is not part of the court can ask for the judgment of the court anyway, voluntary ask, but it has to establish a time frame for the fact on which you want the court to decide. We will see it exactly about Ukraine. 130 states have signed the Rome Statutes, but 30 of them still have not ratified them. So 130 signers, 30 not ratified yet. 41 states never signed or accepted the statutes, and some of them are very important on the international political stage, such as China, India, Turkey, Qatar, and Saudi Arabia. So there are others, but these five, as you see, have they play a role on the international stage, especially China and India, and Europe, Turkey. 4 of the signed states ratified the statute, but later decided to revoke the signature and the ratification. It happened also this. I will see a detail of, at the end we'll see 6 cases that I think is quite interesting. One of the cases that the most simple is the cases that of the state cases about states that ratified but later decide to revoke the signature is Philippines. At a certain point in 2016, the president of Philippines was subjected to an investigation by the court, and immediately he revoked the signature of the treaty, and it was in his power because Philippines is a presidential republic. 4 of the signed states openly declared they are not going to ratify the statutes. Also in this, we'll see in detail, we have 2 important cases. One is Israel, and the other is the United States. We'll talk a lot about the United States in regards to the International Criminal Court. Of all 100 states that signed and ratified, only 8 had signed and ratified countries have also ratified all the 6 amendments to the statutes. So 100 sign and ratify, only 8 approve all the 6 amendments. The states are Croatia, Slovenia, Germany, Latvia, Netherlands, Slovakia, Switzerland, and Uruguay. It's mostly European country. Only 23 of the signed and ratified countries has fully implemented and approved the complementary and cooperative national legislation. This is not something light. No, it's not something unimportant, because without the complementary and cooperative national legislation, it could be very difficult for the court to operate at national level. 50 of the signed and ratified states are on different levels of implementation and approval of the complementary and cooperative national legislation. Italy is among this, we approved the complementary, we are still drafting the cooperative. The remaining 30 of the signed and ratified state never make a step toward the implementation and approval of the complementary and cooperative national legislation. So 30 never do anything. Currently, the state that completed the full process, signature, ratification, approval of the amendment, entry into force of the national legislation connected to the treaty are only 4. Croatia, Germany, Netherlands, and Slovakia. I think it's an important note to say they are present. Croatia, who was very involved in the Tribunal for War Crime during the former Yugoslavia war, and Germany, that was unfortunately fully involved in the Nuremberg trial. I think there are 2 countries that tried to change the path in history. Now, some cases of states that can be, I think, okay, it's already 4. I think it's enough for today because I don't want to keep you more long, and we can see the single cases next time. Are you already there? Are you still there?
Yes, sure.
Okay,
Yeah.
perfect. Okay, before to leave you, I'm sorry if I take you so long, and I hope that I don't have annoyed you too much. I would like to insert in the chat again if they take attachment. No, I don't know. I wanted to give you again the format for I want to, I don't know how it works. Anyway, I wanted to give you also again the format for the question for today's lesson, and okay, but this is I can put on in chat. It's my email that I created for this lesson, for this cycle of lessons. So you can contact me, send me directly your questions, and I sent you also I sent a format also to have a little more information about you, so I can direct my lessons in a way that can be more close to your objective and more close to your interest. My email for the course is the following. Just a minute. Okay. Okay. Thank you for to be so patient with me, and I hope the lesson was interesting for you.
Mr. Fabrizio, we want to say something. We very grateful when you took the time to answer our questions, and your questions were very meaningful. And we're so sorry for the fact that someone could not answer you due to technical problems.
It's no problem. It's no problem. The important is they can give you, they can have my answers, and this is the most important. Thank you again, and have a nice evening, and take care.
Thank you so much. Have a nice evening.
Thank you for
Goodbye.
the lesson.
Bye bye.
Thank you. Goodbye.
Thank you.